welcome everybody to our first. We would have preferred to have started a month or two ago, but I understand there's something happening out there in the country that has the country by storm, and so we're getting our first official webinar here in June, but it's a very good one, very hot topic. So I welcome everybody who's in the audience. I welcome those that are still coming in, but we wanted to get started on time. So our hot topic today is really focused on the virtual mediation process. It's really, like everything else has gone to virtual, the mediation process is no different. And we have today a very distinguished panel with us. The event will be recorded, and we'll have it available for playback. Like I said, we have a very distinguished panel. I'm going to hold off on introductions. I'm going to let our moderator, Paul Isaac, take care of those. But just really to all those on the panel, thank you very much for coming today and contributing to this. I think this is an excellent topic and one that certainly has a lot of interest out there. The timing of the event today, pretty much the open panel discussion will run somewhere between 40-45 minutes, give or take, and then we're going to try to leave another 10-15 minutes, or if there's just a lot of go longer if we need to, for Q&A. And the Q&A might be the most interesting part, because based on what the panelists come up and talk about, you might have a lot of questions that you have for follow-up. So please, I encourage you to use that process. You have a chat box for those of you. I can't imagine anybody hasn't been on the Zoom platform by now, but for those of you that haven't, if you drop down, like mine is on the bottom of the screen, some might have it on the left or right, but there's a panel down there for chat, and that's where you just throw your questions out there. There'll be people behind the scenes looking at those questions and getting them over to Paul so he can kind of ask our panelists one by one, their opinions and their thoughts on those topics. We're going to be, for the most part, in listen mode, other than those folks that are contributing directly to the panel discussion. But again, I emphasize the fact that your voices, we do want to hear them, but we do need to hear them through the chat process. So please take advantage of that. Write down your questions. We'd rather have too many than not enough. And I can't imagine on a topic like this, there won't be enough to make it very interesting. So with that in mind, I hand the reins over to Paul Isaac, Jr., who's going to be our moderator and direct traffic the rest of the way. So thank you, Paul, and take it away, pal.
Thank you, Joe. So prior to March of 2020, attorneys that I know would have bristled at the notion of substituting a virtual mediation for a live mediation. They would tell you that there's no other substitute other than a trial for the rush of adrenaline that they get presenting their case in front of the opposition. And from a settlement planner standpoint, the virtual mediation poses a whole entirely unique set of new challenges. Shorter timelines between the scheduling of a mediation and the resolution of a case make it imperative that planners meet in some capacity with plaintiffs quicker and more readily. So while there are certainly challenges to the virtual mediation application, there are no doubt some efficiencies that we've all been able to benefit from. And we want to talk through both of these points, the negatives and the positives. And to do so, the Society of Settlement Planners has assembled a panel of experienced mediators and planners for the webinar. Our first mediator on the panel is Jeff Kichaven of Jeff Kichaven Commercial Mediations. Located in Los Angeles, California, Jeff has over 30 years of mediation experience. A Harvard graduate, Mr. Kichaven was named the best mediation lawyer in the city of Los Angeles in the year 2015. Joining us from Florida is Scott Baughan of Upchurch, Watson, White, and Max. Mr. Baughan has been a Florida Supreme Court certified circuit civil mediator since 2005. And in 2017, Scott transitioned to full-time mediation practice after his 25-year as a civil trial attorney. From Buffalo, New York is Dan Cavarello, a partner at Sugarman Law Firm. An active civil defense attorney for nearly 25 years, Dan now focuses his practice as a mediator and arbitrator in cases throughout New York State and federal courts. We're bringing in planners from a planning perspective so that you can see both sides here and gather and build tools to help build your practice. On the planning side, we have Joe Destralo from Ringler Associates, who has over 20 years of claim and structured settlement experience His practice is centered in New Jersey. Also joining us is Anthony Prieto, from the president of Synergy Settlement Services, who is also a Society of Settlement Planners board member, and Chris Bua. Chris Bua is the senior vice president of sales for Independent Life and also a board member of the SSP. Chris interacts with settlement planners across the country every day. He's in a unique position to provide some feedback on how the broader industry is adapting to the topics that we're going to discuss today. So we've worked to assemble some questions, as Joe alluded to. We're certainly excited to hear from our attendees in the Q&A session as well. I'm going to make the assumption that those attendees and those of us on the panel have all participated in live mediations, but it would be foolish to make the same assumption for virtual mediations. Our first question, I'll reach out to Jeff Kichaven. And Jeff, my question to you is, how have you seen attorneys approach a virtual mediation setting differently than they would have a live setting?
Paul, thank you so much for the question, and thank you to the Society for having me here. It's a wonderful panel and a great audience, and I'm delighted and honored to be a part of it. And I want to announce that I'm here with good news. I'm here with good news and more good news. I've got more good news than John Krasinski. Lots to tell you guys. And the most important thing is that we have an opportunity now in the virtual environment for a rebirth to the mediation process. Mediation has deteriorated over the last many years. It started out as a curated and managed series of conversations between the sides, moderated and mediated by the mediator. Over the last many years, it's devolved, it's deteriorated to a point where the sides rarely, if ever, see each other in many mediations. And it's the mediator doing all of the heavy lifting. There's really not much for lawyers to do in these devolved kinds of mediations that we've seen in person in the last several years. And so the question is, at the end of the day, in the client's eye, has the client had a meaningful chance to participate in the mediation, or has the client just sort of sat there like a stone and taken what's been handed to them by the mediator as, sorry, but this is the best we can do? And is there room for lawyers to do their best work and earn the respect and esteem and honor of their clients, working shoulder to shoulder with them in the mediation? That has disappeared, and it's not good. It should be the lawyer who the clients see with the big red S on their chest, not the mediator. Now we have a chance to start from scratch. Why is that? Why have we gotten away from the direct communication? It's because lawyers have feared that things would get too emotional and too out of control if their clients were subjected to the direct communication of a joint session. And now we can do it differently. We can do joint sessions in a less emotional way, direct communication, without the same fear and risk of excess emotionality. Why? Two essential reasons. Number one, everybody is at home. And number two, you have control over whether the camera is on or off. When you're at home, when the plaintiff is at home, there's just less stress. That 60-second ride up the elevator to the mediator's office might be one of the most stressful minutes a client ever has. Stomach acid churning, reliving everything that brought them to this unhappy moment. At home, people are dressed more casually, their family's around, they can pet their dog, they're in familiar surroundings. It's just less stressful for the clients. And in terms of the fear that the defense counsel is going to become overly agitated and bombastic, remember the defense lawyer is also in more comfortable and more familiar surroundings. Chances are in jeans and sneakers underneath the shirt and tie. And so it's a more relaxed environment all around, less to fear that people will get agitated. And if the plaintiff does get too agitated, or if there is a fear of excess emotionality, people can turn off their cameras. They can just stop their video and put up their picture or their name, as I've just done. That way, somebody can listen without fear that they're revealing too much of their emotional and agitated reaction on their face. And importantly, the role of the mediator can go back to what it should be, mediating, not hijacking or pirating the lawyer's role in the negotiation. The client has their role in making the ultimate decision. The lawyer, who owes the duty of undivided loyalty, goes back to having the primary responsibility of conducting the negotiation on behalf of the client. And the mediator goes back to the mediator's proper role, which is to act as the kind of anesthesiologist, if you will, making sure that there's oxygen running through the system while the glory players, the surgeons, the litigators, if you will, return to their previous role. So this is a big difference. We have a chance to do it right now. Let's not make the same mistakes. Let's let plaintiffs feel they have a more active role in fashioning the settlements. They'll be happier with the result. They'll be happier with the process. They'll be happier with the performance of their lawyers along the way. Win, win, win. Let's get to it.
Very good. Thank you, Jeff.
Thank you.
So you're saying is this has allowed attorneys to hone their skills and take a more active role in the negotiation. I'm wondering, Scott, do you feel the same way, and how do you feel?
Well, it's a little different perspective here in Florida, because typically well over 95% of our cases do involve a joint session. And so the virtual aspects have been interesting just because I think it allows attorneys to present a more focused review, especially if they're using PowerPoint technology, if they're showing documents, because really it occupies the entire screen for all of the participants. And it's not unusual to have kind of a Hollywood Squares configuration of in some cases, maybe you've got 15 to 20 participants, but when you place them on speaker view, to Jeff's point, you are making that attorney much more robust in terms of where they're coming from. And again, following up on what Jeff said, as far as the emotion, I have felt that the attorneys have tended to be a little better behaved, and I don't mean that as a negative, because they're to be diminutive towards them, but it is easy for an attorney who's been working on a case for a year or two to get highly emotional on behalf of their client or on behalf of their cause. And I think Jeff's right that you let a little bit of air out of the balloon when you're doing it remotely. And so although I think there are negatives associated with the remote aspect, such as the inability to sort of pick up nuanced body language and sort of, take people's temperature on potential pathways to settlement and things like that, you can still do it, but you lose some of the nuance, the appreciation of body language, the appreciation of nonverbal cues are harder to pick up. But it has been good, to follow what Jeff said, to put those attorneys front and center, and really just that speaker view, or where you or spotlight view on Zoom. You click on the spotlight, that attorney has the entire floor, and if there's something they want to show, they get to show it. And people don't have to look, just like in a real mediation. People could look away. They could pretend to look at their cell phone when they're hearing something they don't like that makes them uncomfortable. But even in that scenario, that's offensive to the attorney who's presenting. And you see it happen in mediation all the time, where the people he's trying to convey the information to, let's say it's a plaintiff's attorney, and the claims professional just, when he's talking about the things that are very challenging to the defense in terms of the case. Maybe I do a lot of medical malpractice, and so a lot of times you have the physicians there as well, and it is awkward because the plaintiff's attorney is essentially, and usually in a very professional way, but railing against the conduct of these professionals and saying that they caused harm, which of course they feel bad about, even the prospect of it. So they'll be looking at their cell phones, which agitates the plaintiff's attorney. So it's another interesting side effect of the virtual component. You get the plaintiff's attorney out there front and center, and if people are engaging in these behaviors, which I don't like, but what can you do? I tell everyone to pay attention in advance, but I can't really police their cell phone and sort of their nonverbal indications to a plaintiff's attorney. And you know, it happens on the other side too. Neither side is innocent of that, but it also takes that away. So you have what Jeff talked about, that there's a little bit of a filter or sort of a restraint of the bombast, and at the same time, those kind of nonverbal activities aren't even seen by the speaker. So it does, I think Jeff's right, it lets a little air out of the balloon and allows everyone to really focus more on really the merits of the case, which is usually what mediation is about. You know, trial probabilities, trial optics, predicting, you know, within a bell curve what we think a jury outcome is, and that's where it should be. That's where we should be focused.
Great. And Dan, I'm interested to hear your take on that. If you've seen attorneys, you know, adjust their approach in the virtual setting. And then another question I have that was touched on by Scott is, everybody can see everybody. There's focus all the time. Have you participated or have you mediated cases where there's separate breakout rooms? And you know, what's the practical application of those breakout rooms, private rooms within the virtual setting? If you could explain that.
Hey, Paul, and I appreciate the opportunity to be here as well. I'm in upstate New York, and for the most part, mediations up here that are done in the private setting are typically involve only a very brief joint session. Sometimes the parties don't even really make any type of an opening statement. And I think that has evolved over the years, perhaps partially by mediators, to make sure that we don't get off on the wrong foot right off the bat. If we're trying to develop some collegiality and some cooperation, it's not always productive to have people at each other's throats across the table before we even begin. So the breakout rooms are critical to the process. When this all started, this whole virus situation, which seems like 100 years ago now, I was very skeptical about the technology and frankly a little intimidated by it because I hadn't used it much. But I find that the Zoom, in particular, the breakout rooms, once you spend a little time working with it, really works very well and very much simulates what happens in my office. I kid with people, the only thing that's different is that I don't get any exercise walking from one breakout room to the other. So I have to remind myself to get up a little bit every once in a while. But as long as you create enough rooms at the beginning, you can put people together, you can separate them out. Attorneys still have the chance to speak with their clients separately without you being present. You can jump into rooms, and I typically will text people and let them know, or they can text me and let me know when it's okay for me to come back in. You know, much like knocking on a door when you're knocking, but not really waiting, you're just knocking on it and opening it. That's kind of what I feel like it's similar to. So the breakout rooms are a key aspect of it, at least as to how the process works generally up here.
That's great. I want to shift gears and get perspective from Anthony and Joe here. We're talking about breakout rooms and allowing some privacy, allowing the ability to connect more intimately. Anthony, how are you connecting with plaintiffs and presenting and talking to them during these virtual settings?
I will say, like the mediators have said, it has got the technology, even over the last 2 months, has gotten drastically better. So the ones we were doing at the beginning, the breakout rooms and things like that, were a lot harder to sort of find any functionality in. But now it is very similar to a standard mediation where there's a big opening, then we kind of get sent into our breakout rooms. The problem with the breakout room is for a planner is more just that direct communication with the plaintiff while there's 8 other people on the phone. You know, even though the trial lawyer is helping them resolve their case, they're not always intimately familiar with their, like, you know, their personal finances, and you're trying to have that conversation directly with them while there's 6 other people on a screen staring at you. So that's definitely a little bit harder. So you got to work on trying to do some pre-meetings, doing some more intake type homework paperwork with the client so that you can gather that information. So it's not like you're having a personal discussion about their details in front of 10 other people, which they may not be comfortable with.
Sure. Anthony, while you're on the subject, do you find that the timeline is shorter now? The window of opportunity to consult with plaintiffs is shorter because of the health crisis giving way to the virtual mediations, and a stronger likelihood that cases may resolve in that first mediation?
I think once you have a Zoom meeting with a client, they become really comfortable having them. So the mediation sort of sets that groundwork for them. And after that, it's a lot easier for us to have multiple touch points with them with direct Zoom meetings where they can see us. We still have not done any real in-person meetings in the last 60 or so days. So I think that has actually become a little bit easier versus me calling and scheduling an appointment to drive out to their house or fly to see them. This makes it actually a little bit easier because I still think you need the same amount of touch points to close someone's plan. And this actually has made that a little bit more easier as people get more comfortable with the technology. I think, like Dan said, everybody's intimidated by it. From an 18-year-old plaintiff to a 70-year-old plaintiff, everybody is very intimidated by this sort of meeting. But I think as you use it, it's really user-friendly, and they adapt to it really quickly.
Yeah, I find that it's sort of a leveling of the playing field across the board. Joe Destralo, a question to you, branching off of breakout rooms. What about sub-breakout rooms and allowing a planner to meet with the client directly while plaintiff's counsel or defense counsel go off into their own private room to talk strategy about the case? Any thoughts on that?
The mediations that I've been involved with, I've had my own room. And prior to the mediation, I've talked to the client. So we were on a page, we know where we're going. But I've had very little interaction with plaintiffs per se. I don't know if it was the style of the case or what it was, but, we were in our own room and, we waited to be told, hey, we're going to go here, we're going to go there. So I think, as Dan said, the use of the cell phone texting, hey, can we come in? Can we not come in? So that's been my experience on the mediations I've done.
Great. Thank you.
Yep.
Looking at cases with multiple defendants, Scott, I'll point this question to you. Each defendant has their own room, or can you explain how that would work?
Yeah, each defendant would have their own room, and with multi-party cases, many times, you have one plaintiff. It's is typical that there'll be one plaintiff, but there may be 3 or 4 defendants, and it's possible. And I kind of leave that to the parties. I let the parties drive that, and let counsel instruct me as to how they'd like to be separated out. But there are times when the defense or let's say there's 2 defendants. I've had plenty of cases where they say we're comfortable sharing one room. So when I initiate the mediation, I put them all in one. But then as the mediation evolves and the parameters of the case get a little tighter, it always gets hard at the end. Sometimes they want to separate out. So I'm directing traffic like that often where I'm I've got one breakout room for the defense, but then I make another one. On the fly, and it's very easy to do with the technology. So then I've got 2 breakout rooms. One of the things that is important when you have multiple breakout rooms is keeping the counsel advised by text. As Dan mentioned, at the beginning of every mediation, I give everyone my cell. And then I ask all counsel, if I haven't already gotten it in sort of the pre-mediation efforts, to text me their name. So then I've captured their number. And I keep them advised, because something that happens in a multi-party case is, let's say it's not unusual to start with the plaintiff, get their proposed number on how they view the case, their beginning number. Then to go to defendant A. And then, the first round, there's always lots to talk about. It sort of condenses as we go in future rounds, because we've already said grace over a lot of the merits. But especially that first round, maybe the first 2 rounds, spend a lot of time in each room. And if I've got 3 rooms, one of the things I try to do is tell everyone what I'm doing. When I leave the plaintiff for the first time, I'll text defendant A, I'm coming into you. I'll text defendants B and C to say, hey, I've just left the plaintiff. I'm going in with defendant A. Then when I leave defendant A, I text the plaintiff so they know, and I text, letter C, letter B, I'm coming in. Letter C, I'm switching rooms. These are the things that would happen naturally if you were in an office setting. People kind of, you see people by the water cooler, you see people getting a cup of coffee, you walk into the restroom. So everybody kind of knows that you're making that progress. If you take that away, people get frustrated. People already get frustrated because you're taking so much time, especially early on in a multi-party case. Just the time and motion of going from room to room to room before you then finally circle back to the plaintiff. And so that's something that if you don't compensate with it via text or some other means, it's lost. And it's important because it helps people stay calm. It helps people stay in a frame of mind that is conducive to listening and conducive to that dedication to the process. Frustration levels are down. And the way I've found to do it, I agree 100% with Dan that text communication is a wonderful adjunct to the Zoom platform. But those are some of the that's one of the biggest, or some of the biggest issues associated with breakout rooms and multiple breakout rooms.
Great, thank you. Jeff, did you have something to say?
Yes, I just wanted to say that having that some kind of back channel of communication is really critical. You see, I put my cell number in with my name there, and I ask all the lawyers to do the same so that you can just see what their cell phone numbers are. You just have it right there.
Yes.
And I'm finding that in multi-party cases, different teams will be using Slack. They'll have their own Slack system so that they can communicate with each other on the side. Sometimes people make old-fashioned telephone calls. And it's important to have that because sometimes it's okay to say to the mediator, Mr. or Miss Mediator, would you please put me in a breakout room with this one or that one? We need to have a certain conversation. But sometimes you don't even want the mediator to know who you're talking to behind the scenes. So having some kind of back channel of communication is very important. And as my fellow mediators were saying, doing advanced planning so that you're not just meeting your plaintiff for the first time the day of the mediation. It takes a little time to establish some rapport with somebody over Zoom or any of the other online platforms. I think Dan said it very well. Once you have that rapport set, people kind of forget that you're in different parts of the country or wherever, and it's just like talking to somebody. I think the resistance that we were feeling 2 or 3 months ago was kind of melted away, and I expect that the resistance to it will continue to melt away for reasons that I assume we'll be discussing as our time goes on.
Great, thank you, Jeff. I want to speak to the point about value and case value. We'll put this question to Joe Destralo first and get the perspective on the, from the carrier side and move to Scott from there. If we were to pick a case, say a products case, same case, view it through the lens of a live mediation as well as a virtual mediation, is there any deviation between settlement values strictly based on some of the things that we've talked about here, the deficiencies or the differences between the virtual setting, or do you attribute the difference in value, if you've seen it, to what's going on a global perspective?
The value of the case, the client comes up with a value on the case, and I think that value doesn't change. I think it may change more so when you're face-to-face because of the dynamics in that room versus when you're in a Zoom mediation. I'm not sure those dynamics come across to the examiner or the file handler. So I think the value of the case is the value of the case, but I think maybe in Zoom, you may get I'm not going to say you're going to get a better settlement because there's too many good plaintiff lawyers out there and too many good defense lawyers and great mediators, 3 of them on here. So I think it boils down to personalities, experience, and, you know, what is the value of the case and how are we going to get to that number? That's what I've seen.
Great. Scott, I asked you the same question. Oh, go ahead, Jeff.
Scott, please, and then I'll follow.
Okay, same. Yeah, I think that I agree with Joe that, you know, it hasn't changed really. I think what all of us would refer to as the normal valuation metrics. You know, we're looking at, you know, what are the economics, how appealing is the plaintiff. That's the one thing, those intangibles as to how appealing is a plaintiff, because that dramatically can change how the defense perceives their exposure. If it's a really nice plaintiff that they think the jury's going to fall in love with, on the same set of facts, they see more exposure. But usually they know enough about that in advance that, like Joe said, it's already factored in. The second part of your question, Paul, I've seen 2 things that are not necessarily a product of Zoom, or of moving to Zoom, but are a product of kind of the COVID crisis in general. And there's an advantage for defendants simply because when are you going to get a jury trial? Jury trials, you know, they're experimenting with doing those virtually. That hadn't gone so well. There's a lot of criminal backlog that needs jury trials, and those have constitutional time limitation requirements that have to be observed in some form or fashion. So there's a certain, you know, just the age-old maxim of a fast nickel beats a slow dime advantage defense, because when are you going to like, for instance, I'm constantly mediating cases that were set for trial in July, but have been taken off the docket, and who knows when they're going back on. So again, advantage defense. The other thing that I've seen, and I never saw it very much before, especially in the context of healthcare defendants, products defendants. Sometimes they're coming up, and if they have a large SIR, self-insured retention, associated with how they're evaluating the case, sometimes they're just saying, we're not settling anything. I've had a few mediations cancel outright because key defendants in a multi-party case said, we're not even going to consider it. We're trying to figure out how to pay payroll. It's been a big factor associated with some of the larger physician groups throughout the country who elective procedures were canceled. That's a huge cornerstone of their financial model. And so you've seen that as well. One thing I want to jump off a tiny bit, Paul, because I think it's sort of unique in terms of opportunity for settlement planners. One of the things that I've been doing is I'm looking at every case that impassed in the past, 8 to 12 months, and I'm calling the plaintiff's attorneys and I'm saying to them, any thought of revisiting? Can I re-engage on this at all? Because of course they want to keep a poker face, but they know the realities of they're not going to get a trial date anytime soon. And their clients may be more motivated by virtue of the negative economic circumstances from a macro standpoint. So I think that to the extent that settlement planning professionals in the audience, might want to do the same thing, simply because sometimes it precipitates a reevaluation in a case that didn't settle. Now maybe it has a catalyst to settle. I just wanted to that's a little off your question, but I think it's important from the settlement planning sort of business and marketing standpoint.
Oh, that's great. Thank you. Jeff, you had something to say in that.
Paul, I agree with what Scott was saying, that there are many cases where defendants simply have higher priorities for their money, paying the rent and the payroll and keeping the lights on. In those cases that are coming to mediation, though, I think that there's a secret weapon that plaintiff's counsel have not been using to the fullest advantage, and that's the plaintiff, him or herself. And in many cases, the plaintiff's lawyers keep the plaintiff under wraps, don't expose the plaintiff very much to the defense side or even to the mediator. And I think that can change, again, because we have a cooler emotional environment when people are speaking from home. I think that sometimes the plaintiff, him or herself, is the strongest tool. Yes, cases have the value that they have. I agree with that statement as well. And at the same time, we can, from the plaintiff side, you can change a defendant's perspective of what a case is worth. If they get to see, here's the plaintiff, they're calm, cool, and collected. They make a good impression. They're articulate. They tell their story. People will empathize with this plaintiff. They're nice people. They're maybe compelling in certain circumstances. And there's more of a chance to rehearse in advance what that plaintiff is going to say and how they're going to present it directly to the other side. So let's not underestimate the fact that in many cases, plaintiffs can enhance the value of their cases by engaging in more direct communication and making the kind of an impression that simply cannot be conveyed any other way.
That's great. And to run off of that, Dan, a question for you, and presenting the plaintiff and having them be a more active participant. How do you see, or have you experienced in your mediations, discussing that in the framework of a jury trial, and how a jury would approach these cases whenever that or whatever that looks like, and whenever that may be, in terms of value and how the plaintiff might present?
Well, I certainly agree with what Scott and Jeff have said about not necessarily Zoom, but the COVID crisis, I think, has changed the perspective by some folks who may have had higher expectations. And once they find out that their July of 20 trial is now December of 21 or something like that, that definitely can have an impact on their expectations. And I think also this speaks to a point that Jeff made earlier about people being at home and maybe being a little bit more relaxed and being able to get up and take care of things. I do think that A, they may come across a little better in that environment, but B, they're also talking on camera to a relative stranger or strangers, and that can be a little nerve-wracking. And I think that can be utilized to say, you're trying to convince me of what your case is worth. I'm just one mediator here. Imagine what it's like sitting over in a courtroom in a witness chair with a bunch of people staring at you and trying to convince those people. So maybe it gives them a little bit of a preview that's a little bit better than just being in an office. They probably already did that at their deposition, but now they're sitting on camera and people are talking with them. And there might be a pressure point there for people. Do they really want to go to the next step as far as ending up in a courtroom and not knowing when that might be? I do think that one thing that I've learned doing this is, I think, and my background before was in defense work, I think people on the defense side sort of sometimes maybe underestimate or don't realize that there's a pressure point there with just how nervous and how emotional and how difficult it can be for plaintiffs just to get through the system, how stressful it is, not knowing what's going to happen, when it's going to happen. The other side has the money. Are they ever going to give me any of it? I mean, I think those things are just stressful for people that don't live in this arena. So if that's a stressor of yours for 3 years, and now you tack on all this other stuff that's going on, and then you tell me I got to go over to the courthouse, that's a lot for someone to deal with. So that's my perspective on that, I guess.
Thank you. You talk about the cameras being on and presenting to a panel of folks that you wouldn't, you don't know or aren't familiar with. With the camera being on all the time is the new way of life. Everything is always on demand. Dan, have you experienced parties losing focus through the course of a mediation? Just general Zoom fatigue, as they call it, and how you have recommendation for or tactics that you see employed that kind of cut through all that?
Well, I think what Scott said earlier was a very good point, just in terms of keeping people informed about what's going on. I mean, if they are at home, they are able to sort of take care of other things. If they know it's going to be an hour before you're going to get back to them, then it's a courteous thing to do to say to them, it's probably going to take me a little while to come back with you, and I'll text your lawyer when I'm ready. But it's important that I spend time with these other folks if you want me to convince them to your way of thinking. So I think a good way to try to temper that fatigue is to keep people informed. And Scott's right. You have 4 parties involved in a case. Sometimes you're trying to remember who you told what to, and it can get that way as the day goes on. But I think if you keep people informed, that helps. On the other hand, sometimes I think fatigue can be helpful to getting a case resolved. I think sometimes people, after they've been invested in several hours, and they don't want to waste the whole day and have nothing get accomplished. So sometimes having it go a little longer, I think, can be a benefit, because it gets people more interested in really getting to a resolution and not having to go through it again.
Yeah, go ahead.
Follow up to what Dan was saying is one of the things that we've lost is lunch. You start a mediation that you think is going to go all day. If you can get them to eat lunch, your chance of settlement has gone up dramatically. And so you've lost kind of that sort of transition from, it's a great transition from morning to afternoon, and everybody gets a little bit happier because it's nice to break bread together and everybody relaxes. So we've lost lunch. And what it just occurred to me, as Dan was talking about that people do get worn out, but at the same time, that represents investment. That represents investment of time and not wanting to let go of the several hours they already have in it and walk away with nothing. So
that's great. I want to kind of stay on this topic before we shift back to the planning side and get Anthony's perspective as well as Chris's. You talk about the fatigue playing a factor. To the mediators, do you see cases being resolved in that first meeting on a more regular basis? Because, for instance, the adjuster doesn't have to catch a 3:30 flight. They can stick around. We know they're at home. I'll go to Jeff first. Has that been your experience?
Well, I don't think we're in it long enough really to generalize very much. I do think that people, once you get that momentum going and you have people engaged, you are more likely to get a settlement. And for the faraway insurance adjuster or the quote unquote real decision maker, whoever he or she is, I think we're getting still only partial attention, but we're getting a greater share of the real decision maker's attention with the video channel rather than just, we all do the mediation all day, then at 5 o'clock in the afternoon, we call to the real decision maker and say, we need more money, or will you take less money? So the whole issue of partial attention is a complicated and interesting question. We only had partial attention even when people were there in person, because they're multitasking. There were comments earlier about people checking their cell phones, looking at email, and we're glad that people have other things to do because we may be away for them for extended periods of time. That's a good thing, and it's easier for them to do that multitasking when they're at home. One question that's going to arise in the future is when there's some possibility of being in person, do you want to come in person or do you want to be available on video? And I think that if other people are going to be participating by video, you probably want to participate by video too. Because for the other side, so to speak, who's on video, if they don't like the way things are going on or they don't like the pressure the mediator's putting on them, it's very easy for them to turn off their video or just say, bye-bye, I'm out of here. And with one click of the mouse, they're gone. Whereas the people who are physically present are much more invested, if you will, and much more subject to pressure. So I think it's going to be a long time. I know there's another question on your list. I think it's going to be a long time before we get back to in-person mediations. I think just coming into office buildings for the next many months is going to be a very difficult thing. In the 50-story building in downtown Los Angeles where I have my office, I think they're only going to allow 2 people into an elevator at any one time. And there will be similar distancing requirements in office buildings all around the country. And our landlords are going to be imposing that on us, those kinds of restrictions. When you're in a conference room, are there going to be plexiglass shields between people sitting at the sides of conference tables? What's it going to be like? How are people going to get in and out of the bathrooms in office buildings? Will the coffee machines be operating? It's not going to be like an on-off switch where we'll be able to go back and to doing our mediations in our offices in anything like a routine fashion anytime soon. So these are also things to which we have to adjust and realize that for the foreseeable future, I think video mediations are going to predominate.
That's great. Thank you, Jeff. Dan, any trends in terms of resolving in that first shot here? Is it, as Jeff indicated, too early to tell?
I think it is definitely early, but I have had some cases that were supposed to be tried this summer. And at least in this part of the country, they're not, the timing of trials is very uncertain. And I think, we had plaintiffs who are all worked up and ready to go potentially this summer, and they don't know what's going to happen. On the other hand, removing the pressure points, particularly I think on the defense side, sometimes means the file just ends up at the bottom of a large stack of other files, and the people on that side sometimes with the money become less interested because they're not shelling out their money for counsel to prepare for trial or their experts and such. So I think it may be more difficult to get defendants motivated if there's really no certainty regarding trial dates, and I've seen a little bit of that as well.
Great, thank you. Love to, as I said, shift gears here and get Anthony's perspective on things. Anthony, having participated in a number of mediations, which I'm sure many more than the plaintiff attorneys that you're working with, is there advice? How are you prepping them for these types of meetings? I'm sure you're working with attorneys who it's their first instance of this, and likewise, the plaintiffs themselves. Are you afforded the opportunity to meet with them weeks, days before mediation? How's your daily practice operating?
We've done more prep with the plaintiff lawyers beforehand. The plaintiff themselves has typically been the same thing, where we find out about a mediation and meet them at it, or if it's an attorney that wants to do the pre-meeting, we'll do it. But I mean, like some of the mediators said, I think one of the powerful things is when the plaintiff is catastrophically injured and they're at home, it's almost like during that opening session, it's a day in the life video because they get to see what it looks like, versus an in-person mediation. The plaintiff does everything they can to look as normal as possible. Whether they're a paraplegic or whatever, they're all dressed up. They look much nicer than their day-to-day life would be. So I think it's powerful for them to see it. There is some technology disadvantages of like trying to show videos during these that I've seen as negatives, but from an overall planning practice, we talk to the attorney and just tell them the pros and cons of the mediations that we've been in the past. My only outside thing that I would say is that I do think there's been a little bit, and Joe sort of said it, it doesn't seem like people are picking up on body language as much, or they're much tougher during a virtual mediation. I've seen people start out with crazy demands and even go up on their, when the mediator comes in and says, okay, what do you want to take over? They present a demand that was larger than the demand package they sent over because they're offended by the initial presentation. Just things where usually someone like Scott or Jeff or Dan would be able to talk them down in that. It's a lot harder because they're building themselves up in this side room like, that was so offensive. I can't believe they said that about me. And then by the time Scott walks in, they're not as willing to listen to Scott's advice. They've already talked themselves into a crazy demand that almost ends in mediation. So right. I think a lot of stuff works similarly. I do think, like Jeff said, the fact that you'll be able to get people in a room probably with a 12-hour notice to do a mediation the next day is going to speed up mediations the second half of the year, whether or not your part of the country is opened up or not. People are going to do these virtual things, or at least some people will be virtual. Maybe a group will be in one room and then there'll be 3 people virtual. I think there's going to be a lot more mediating happening the second half of the year than has happened on the first half for people to catch up, which will be great for everybody.
Agreed. Chris, you're in a pretty unique position there with Independent Life. You serve as a sounding board for brokers and planners throughout the country. What challenges are they coming to you with? What are some success stories and something that they're stumbling blocks?
Sure. Before I get into that, I did want to piggyback off what Scott said, that we have lost lunch. Today was my first lunch out in 2.5 months. And lo and behold, I bumped into a buddy of mine who's a personal injury attorney. And he asked me what I was up to. And I said, well, actually, in a couple hours, I'm going to be talking to probably 70 people about virtual mediations. Have you done any? And his feedback was he has not done mediations, but he's done several depositions over the last couple months. And he felt that the adjusters didn't get a real full appreciation for what his clients were going through, the injuries that they had suffered, not nearly as much as they would if they were in the room with the injury victim. So he would not continue to do video depositions beyond COVID. He would rather do those in person. And then I asked him, after COVID, what processes in your practice would you kind of switch full gears towards this virtual setting? And he said that if he could do hearings on uncontested claims, that would save him time, expense, and he'd like to see the courts transition to doing more of those on Zoom type settings versus having everyone come down to the courthouse. So I thought I'd share that with you guys. As far as settlement planners, the most common theme I've seen is that they're having a hard time making a personal connection with someone versus how they get that connection when they're at the table with them in person. So if you're pitching $1 million, $2 million, $3 million plan, if you're not building that rapport in person and you're doing it on video, it's not as effective. And we think over time, the win rates are going to go down. So it's one thing to kind of go over a college plan for a $50,000 premium with parents on Zoom. That's fine. But when you're getting into some of these high dollar settlements, to a lot of what Anthony said earlier about personal information that maybe the client doesn't want to get into with 7 other people on the call, you lose that ability when you can only meet virtually. They do think it would be a good tool to use for follow-up meetings. So have that initial meeting in person and then be able to do follow-up meetings and finalize the plan over Zoom. They'd like to do that even beyond this quarantine, this shutdown. They'd also like to see it done more frequently on smaller value mediations and then routine settlement approval hearings, kind of like the PI attorney that I mentioned earlier, which to get in front of the judge, I think is a sneaky good marketing opportunity. A lot of times judges will see cases where money is being put in guardianship accounts and they will say, well, you should contact so-and-so. They can set this person up with a structured settlement. I know when I was on the planning side, we got frequent referrals from judges who thought it was more in the best interest that it be annuitized than to just have it sit in a guardianship account. So if you can get that FaceTime on a Zoom meeting with a hearing and not go there, that's effective. Also, I've heard using it kind of on the second mediation, doing Zoom as a follow-up mediation versus the initial mediation. Long-term, that would be something that would be useful and effective. And then they have found to have many technology challenges, and they found that the younger plaintiffs, it worked better because it's more ingrained in their daily life, whether it's FaceTime, et cetera, that they're used to communicating that way. So cases where there were older plaintiffs, it was more of a struggle. And those are kind of the general feedbacks that I've heard from planners. That's
great. Thank you, Chris. There's a lot of great takeaways there. Just one thing about the attendee submitted questions. There should be on Zoom a Q&A box. If you could try and submit those questions through that route, that'd be great. I think some folks have been submitting them through the chat and we've been missing them, but we've got a couple minutes here. I want to make sure we get to those attendee questions. I've got 2 more questions for the panelists. Just generally, we can open this up to everybody. Do you think the virtual mediation we've talked about, we're going to see it for a while. It's here to stay. Whether, as Chris just said, it's a second layer after that face-to-face, or this is the preferred medium. What's next in the world of mediations? Is there something beyond this, or where do we go from here? Jeff, I'll turn to you first.
Thanks, Paul. Well, who knows what the future is going to bring? 6 months ago, who would ever have said we'd be where we are? I think what we're going to see next is a realization that video mediations do have many advantages. There's some disadvantages as well. And I think we'll be in a situation similar to where we were 25 years ago, when mediation itself was becoming ingrained into the culture of litigation and conflict resolution, where we got to a point where people, they didn't have a mediation in every case, but they considered whether or not to have a mediation in every case. And I think we'll come to the same point in video mediations, where in every case where there is a mediation, people will say, should we do it by video? Should we do it in person? How should we do it? We can eliminate the cost of air travel and get direct participation of people from all over the country or all over the world. We can schedule our cases on much shorter notice. Those advantages are not going to go away ever. And we will be involved in social distancing for in-person mediations. People talk about body language and whatnot. Well, picking up body language may be challenging on video, but it's also pretty challenging if you're sitting on the other side of a plexiglass shield wearing a mask. That's pretty hard. You can't even see somebody's facial expressions that way. So I think we're going to get to a point, maybe we already are at a point, where video mediation will be as routinely accepted and considered and used as mediation itself.
Thank you, Jeff. Dan, your thoughts, and if we get to a point of live mediations, is it the duty of the mediator to set parameters for social distancing? There's common knowledge, of course, and courtesies, but from a liability perspective, is that any concern?
I think if you're inviting people to your office, you have an obligation to make sure that it's safe. I think that whatever concerns people have, I think those should be addressed up front. And, if they can't be fully taken care of, then you offer people the opportunity to participate on video. I mean, one of the things I like about the video option is that we have some plaintiffs attorneys in my area who get frustrated when they bring their client and the claims person doesn't show up, or the third-party administrator doesn't show up. The money person doesn't show up, and the excuse is, well, they're in Los Angeles or they're in Florida, and it's just they didn't want to travel, they weren't sure if this was going anywhere. So having the Zoom option, I think, really eliminates that excuse for people to say that they don't want to incur the expense or they don't want to travel. So I agree that I think that the video, it's either going to be an option or it's going to be something that is just done for the foreseeable future. And I think it's very important that ahead of time, everybody knows what everybody's agreed to do. We don't want a plaintiff thinking that they've come to an office and someone else didn't, or vice versa. I think we want to make sure that it's up to the mediator, make sure everybody's on the same page with that. The best way to ruin a mediation is to get off on the wrong foot. So we don't want any surprises. And I think we're going to have to be more diligent, myself, Scott, Jeff, to make sure that those issues don't come up because of this new way we're doing this.
Mm-hmm. Great. Scott, same question, and bringing in a question from the Q&A. What about, have you had any special techniques to help bridge the gap at the end of a mediation where you need concessions from either side to get to resolution? And is that a challenge in the virtual environment?
Well, I don't think the technique has changed much. I mean, and as mediators, it's such an individual approach. I mean, I'm sure that Dan and Jeff and I do a lot of the same things and use a lot of the same kind of blocking and tackling techniques. but you know, there's nothing that beats rapport, and there's nothing that beats, you know, so for me, I usually try and see if I can get them to engage and lighten the mood, and I try and inject humor in it when I can. Not all cases lend themselves to that, but many do, even when they're serious cases with serious implications. And so, you know, that's something that's harder to do. So again, it's that lack of, because the last thing you want to do is the worst thing about trying to, you know, lighten the mood is offending someone, because then you're in big trouble. And you can kind of, again, the nuance of body language is a little bit lost. You know, at the end of a mediation, you know, I will oftentimes, you know, I find that a lot of times participants will ask me, you know, where do you think this could go, kind of thing. I like it when they ask me that, because it gives me a chance to sort of, you know, tighten the parameters of, you know, where do I think the other side might find happiness, and you know, I can take their temperature. It's not really different from that technique in general from a live mediation, but in virtual, it's sometimes it comes a little more directly. In other words, it just comes to a point where everyone just starts sort of saying a cut to the chase moment. And I think a lot of us that always see, you know, the witching hour of 5 p.m. as a fantastic catalyst. And it is nice, though. Somebody mentioned, you know, the adjuster doesn't have to go catch a plane. That's a huge benefit of a Zoom mediation. Everybody still has motivation that when the workday is over, let's stop working on this if we can get it done. So let's kind of cut to the chase. But you don't have that cutoff where, you know, then you only have access to the adjuster because the attorney can call him or her on the cell phone while they're racing to the airport because they stayed as long as they could. And so that's a positive. And so also people being more willing to work late is a positive as well.
Yeah. Great. Thank you, Scott. Now we're at 3 o'clock. I appreciate everyone for staying on. If the panelists are open to it and the attendees, we've got a couple more questions and we can dig into the Q&As. One question for Joe and Anthony: as the virtual mediation becomes the new normal, have you at all tried to leverage that by expanding your practice into new jurisdictions maybe you couldn't physically touch? You know, your marketing approach to firms. Are you saying we've got the best product, or we can help you, we're the most qualified to help you, you don't need to pull us in from Florida or New Jersey, we're right here now? Joe, you want to lead that off?
Sure. With my, you know, my clients take me all over the country as it is, so I'm everywhere. And it's ironic, most of my mediations were not in New Jersey or Philadelphia, so they were in different places. So in that regard, to me, it's business as usual, business continuing, staying close to your clients, and you know, when you're ready to go, you're ready to go. It was funny. Go back. Scott mentioned something. I think it's pretty important. I'm seeing some clients, as Scott said, there's not a sense of urgency to settle a case, whether it's the fact that, you know, they have bills to pay, the upper management, or there's no trials coming up. And so as a result, there doesn't seem to be a real sense of urgency. You know, so it's going to get interesting over the next several months how this, you know, goes forward, I think.
Great.
If I could jump in there real quick.
Yeah, of course, Chris.
I've heard kind of a tug of war thought where the adjusters and the defense are thinking that plaintiffs are going to make more concessions because of the delays and settle for lower values. And then I've heard plaintiff attorneys, very, very prominent plaintiff attorneys, say that they think verdicts are going to be higher out of this because people are going to be more compassionate because of all of us going through what we've went through as a nation with this quarantine, that people are going to be more compassionate and look at things differently when they're on the jury and give higher results. They're going to feel like we've been all in this together, and it's going to be more compassionate. So
to mediate what Joe and Chris have said, I think the good cases are settling. The ones that have issues and moles on them are just getting kind of pushed back. So I've seen really big cases settle that had real distinct liability, and the carrier knew it and they paid, you know, in similar fashion. But I think both sides are going to have interesting arguments to why they're going to settle for less or why they're going to settle for more moving forward. I do think you have a chance for your practice to go out more nationally. I mean, we've been national for 5 to 10 years now. I mean, for us, it's a huge cost savings, frankly. I don't have to make 3 trips to go see a client in Wichita. Then I can do 2 Zoom meetings and maybe an in-person meeting. So I'm hoping, you know, my life will change a little bit, and that maybe 1 in-person meeting versus 3 as we move forward. But yeah, I do think you can get some more scope out there.
On the settlement aspect, I have seen, and again, this is just anecdotally, but I have talked to some of my mediation colleagues at our firm, and we have seen plaintiffs becoming more motivated. But it's interesting what Chris said, that, you know, as we get closer and closer back to normalcy, I wonder if it doesn't snap back, because then they've already walked through the desert with the case and waited with you know, little hope of getting a jury trial, and now they haven't. And so then I wonder if it doesn't tighten back up. And I really am intrigued by what Chris said as far as what the feedback he's getting from plaintiffs' counsel, that they expect more receptive jury pools. I do a lot of medical malpractice mediations, and so that's interesting, because a lot of what I'm getting from the defense is that the doctors and nurses are the heroes of COVID-19, and so they're singing that song on the defense side. So the competing narratives are interesting always.
That's a very good point. To Scott's point about plaintiffs maybe moving more readily, accepting offers, Anthony, what about from a strictly structured settlement planning side? You've got a case that's come to resolution and the plaintiff is anxious to get the funds. Have you seen it impact your planning approach? Do you find fewer folks are utilizing structured settlements? I'd like to hear Chris's perspective too.
I think for us, it's been, I mean, we track a lot of stuff. Our average case size is still the same. The amount of cases we're settling is down due to the fact that just less cases seem to be settling at this point. So I don't know that on a per case by case, we're any less likely to structure, but we're definitely seeing less cases that get to the actual full settlement that we can, present some sort of plan that involves a structure.
Okay.
I mean, I'm thinking that'll bounce back at the end of the year. That's my general thought.
Yeah. From a provider perspective, we slowed down later than everybody else because we're kind of later on in the process. So we were still busy in March, even into April. And then mid-April through probably the 3rd week of May, we were slower. And then the last two weeks or so have been much more normal pre-COVID-19 flow. So our average size has not really changed. It's just the number of looks that we got dropped in the kind of middle of the quarantine, and now it's picking back up.
Great, thank you. Well, Joe DeGangi, I'll turn it over to you. I want to thank all the panelists for their participation. Unless Joe has any more question and answers, let's take it from here.
No, I also want to sincerely thank everybody on the panel. I mean, I knew this was going to be a good presentation and a good discussion, but I didn't know it was going to be this good. You guys did phenomenal. I think everybody in the audience would agree if we had everybody out there to agree with us directly. It's probably one of the quickest hours that we spent on one of these events. I wish we could go longer. I really do. Maybe we'll have some type of a follow-up in a few months and see where we've gone from here, because it's still going to be a new process even a few months from now. I learned a lot of interesting perspectives, some that I expected and some certainly that were unexpected. So definitely worth the time to do that. The SSP is very proud to have presented this panel discussion. We really appreciate your time. If you're not a member of the SSP, please consider joining. This is the type of stuff we discuss on a fairly regular basis. Maybe not this topic for sure, but certainly hot topics worth discussing. And it's a like I said, if you're not a member, consider joining. Look for future webinars on a monthly basis now that we've kicked off our year. Like I said, a little bit late, but now that we've kicked it off, we plan to keep doing one, every month on hot topics and some case studies as well as we did last year. So thank you, everybody. If there's any other last minute comments, if not, we'll call it a wrap and revisit this maybe in a few months.
This was great. Thank you so much for inviting me.
Okay.
If anybody has any other questions, my cell phone number is posted there, and I'm happy to answer any other questions anybody else has. Thank you. It's a wonderful experience.
Likewise. Thank you very much. It's an honor to participate in it. Appreciate it.
Thank you, guys.
Thank-
You did all the
thank
work.
you.
Thank you.
Thanks, Joe.
Thanks, everybody. Great job
Thank you.
moderating, Paul.
Thank you.
Okay, nice job, Paul.
Thanks.
you.
Everybody.
Good job,
Take care.
Paul.
Thanks.
Bye, guys.
Bye-bye.
Bye-bye.
Thank you.